Welcome to B'madzaji Ginonindwa. This podcast is produced by the Communications Department at the Anishinaabeg Nation. We will be focusing on the issues and initiatives in Anishinaabeg Nation territory. I'm your host, Lisa Abel. Since 2016, the province of Ontario has observed Treaties Recognition Week during the first full week of November. Treaties Recognition Week was launched in response to the Truth and Reconciliation Commission's calls to action to increase treaty awareness and to provide students and the public with an important opportunity to learn why treaty rights and relationships matter. In 1850, the Anishinaabe entered into two treaties with the British Crown, the Robinson-Huron Treaty and the Robinson-Superior Treaty. The Robinson-Huron Treaty territory stretches along the north shores of Georgian Bay and Lake Huron to Batchewana Bay, just past Baoting, also known as Sault Ste. Marie, and inland up to the height of the land. The Robinson-Huron Treaty area has been estimated to contain over 92,000 square kilometers of land. In both treaties, the Crown promised the Anishinaabe signatories an annuity payment that would increase as resource revenues within the treaty territory increased. The annuity rose from $1.60 to $4 in 1875, where it has stayed ever since, even though billions of dollars have been generated from resource development in the territory since the treaty was signed. In 2010, 21 First Nations established the Robinson-Huron Treaty Litigation Fund to seek compensation for the Crown's failure to respect the Treaty Augmentation Clause. Legal arguments in the annuities case began in 2017 at the Ontario Superior Court of Justice. Justice Patricia Hennessy ruled in favor of the Anishinaabe in stages 1 and 2 of the trial, asserting that both Canada and Ontario have a mandatory obligation to review the annuity amount and a responsibility in upholding the treaty. Stage 3 of the process would have dealt with the Anishinaabe claim for compensation. However, instead of returning to court, Robinson-Huron Treaty Anishinaabe and the governments of Canada and Ontario entered into negotiations and in June 2023 announced a proposed settlement of $10 billion for past compensation. This settlement agreement was finalized in 2024, and the parties also committed to negotiating the implementation of the augmentation promise going forward. As part of the Anishinaabe Nation's treaty education efforts, we are pleased to share a conversation I had with Mike Rastool, chair of the Robinson-Huron Treaty Litigation Fund. Mike Rastool is a citizen of Nipissing First Nation. His Ojibwe name is Washushk, muskrat, and he is of the Turtle Clan. He has been involved with the Robinson-Huron Anishinaabe efforts for treaty justice since 1992. Mike is currently the chair of the Robinson-Huron Treaty Litigation Fund and one of the representative plaintiffs in the annuities lawsuit. In our conversation, Mike Rastool shared why the Anishinaabe asserted the need for a treaty in the 1840s, how the Anishinaabe First Nations came together to create the Robinson-Huron Treaty Litigation Fund, and why our treaty relationship will continue to be important in the future. So miigwech, Mike, for being here with us on the podcast today.
Thank you for inviting me.
Miigwech. So to start, would you like to tell us a little bit about yourself?
Okay. I was born in Dokis First Nation. I was born and raised there, and I went to school in Sturgeon Falls, just west of here. And I grew up basically between Dokis and Nipissing. Dokis being my father's First Nation, and my mother's First Nation is Nipissing. So I basically grew up, back and forth kind of thing. I got hired on at the railway, Ontario Northland Railway, in 1970, and I transferred to Nipissing in 1972 because my work was here in North Bay. So I moved to Nipissing, and then I had a 31-year career at Ontario Northland Railway, and after I left there, I started to work with the Union of Ontario Indians. And I spent a lot of years here as well in the Restoration of Jurisdiction Department. And during all that time, starting in 1992, I was elected on the Council of Nipissing First Nation, and as a result of that, the chief asked me to keep an eye on what was happening with the Robinson-Huron Treaty annuities matter. So I started to attend all of the meetings with the chiefs on that, and they've asked me to continue to work with them, and since that time, I've worked on the annuities case. So it's been a long journey, and here I am today, and I'm still going at it.
So that's over 30 years
Yes.
that you've been involved working on this RHT
Yes.
annuities case. That's amazing. So it's taken up a large portion of your life. Well, if we talk about the Robinson-Huron Treaty itself, it was signed in 1850. What events led up to the negotiations for this treaty?
The Royal Proclamation of 1763, where the Crown said they would not allow people to take land that was reserved for the Indians without the Crown. You know, the Crown would be the only entitled to take land from the Indians in North America. And at the time, they started to do these treaties with Native people. There were some agreements, treaty arrangements, basically in southern Ontario that were negotiated as well. But I think that the Robinson treaties were the ones that really initiated the process in Canada for treaties with the Crown. What happened in the time before 1850, people began to settle in the treaty territory, and so the chiefs in the area began to complain about that to Crown officials, and they said, "We have no treaty. You can't move into our territory unless we have a treaty, because in the Treaty of Niagara, you said that you would not allow people to take over the land unless it was through the government." So they met a few times, and Chief Shingwakos of Garden River and Chief Nebenegoching, the chief of Batchewana at the time, were the leaders for Robinson-Huron Anishinaabeg at the time to speak to the Crown officials. So when they did the proclamation in 1763, the Crown said they would not take land. Nobody would be allowed to take land unless it came through the Crown officials. So Shingwakos made reference to that, to the Crown officials. As a matter of fact, the governor at the time, he said to the governor, "You can't take our land because this is what you said in your own proclamation in 1763. Shingwakos said, "You cannot come into our land unless you have a treaty, and there's no treaty, so you can't come here." Just before 1850, Shingwakos said to the Crown officials, "I see people here, and they're taking trees out of the forests, and they're digging up out of the ground some metals and things, and this is our land, and you cannot take any of this away." And then as well, he said, "If you are going to do a treaty with us, we want our share of what you're removing from our land." So that's where this augmentation clause came about in the treaty. Well, they kind of ignored that for a little bit. And then what happened is there was a mine that opened up in Mica Bay on Lake Superior. Shingwakos and a number of Anishinaabeg went there, and they shut the mine operations down. Well, then that got the attention of the Crown. So the Crown then sent Robinson to meet with the Anishinaabeg and to negotiate a treaty agreement. They met in Bouting, which is now Sault Ste. Marie. They met there in the Hudson's Bay post. And they sat down with they called the principal men of the Ojibwe people, and began to negotiate a treaty. And the Robinson Superior Group signed the treaty first, and 2 days after, the Robinson Huron Anishinaabeg signed the treaty with the Crown. And that's how basically in a nutshell, how the treaty was formed.
So it is a really important moment then in our Canadian history.
Absolutely, yes.
So the Anishinaabe were really asserting their rights to their land, their existing rights.
That's right. And, there were a lot of assumptions, I think, that were taken, because I think the Crown felt that the Anishinaabe were giving up the territory to the ownership of the Crown. On the other hand, the Anishinaabe didn't feel that it was giving up the territory because they agreed to a sharing of the land. And that was Anishinaabe tradition in those days, and it still is. There was no word in Anishinaabe language at the time of the term surrender. There was no such a thing as surrender in those days. And the Anishinaabe never believed that they surrendered the land. They agreed to share the land, and that the Crown and the settlers could use the land as well as the Anishinaabe could use the land. And the intention on the part of the Anishinaabe were to share the land and share the wealth of the land. Anishinaabe would retain a lot of their privileges in the land because it was their land. So that's where wording like in the treaty that says, they would be permitted to hunt and fish and in the way they used to do, So that's where the wording came in for that. But it's more than that. It's more than that because the Anishinaabe have an interest in the land, even though a lot of the title, the patent title for the land is held by the Crown. The Anishinaabe still have an interest in the land.
The Robinson-Huron Treaty included an augmentation clause that required the Crown to exercise its discretion to increase the annuities payable so long as it is not incurring loss. Why was this annuity escalator clause so important? And did other treaties at the time, in that time period, have similar provisions for an escalator clause?
The Robinson treaties are the only two in Canada that I'm aware of, and I think that a lot of historians are aware of, that have this augmentation clause, where the annuity would be increased from time to time, based on the judgment or the good graces of the monarch at the time. That was the intention that the Crown officials and the settlers who came to Canada, that was their impression of what the treaty entailed. That was not what the Anishinaabe understood. The Anishinaabe understood that it was a sharing of the riches of the land, not that the Crown owned everything and decided to give anything to the Anishinaabe. So in those days, when Shingwakos and Nibinagotchi led the negotiations for the Robinson-Huron Anishinaabe, they said that they wanted $10 per head to go to the people in payment for use of the land. Treaties in the USA were being paid at about $10 per year. And I guess in those days, $10 was quite a bit of money. The Crown said they didn't have that kind of money to pay that. Anyway, so what happened then is Robinson suggested to the Ojibwe negotiators that what if we were to add a clause that if we make more money in the land, we'll increase the annuity when we can, as long as we don't lose money by doing it. So that's how this augmentation clause came about. The understanding of that by the Ojibwe were that the annuity would be increased. And the court clarified that the annuity is 600 pounds of provincial Crown currency. not $4 per person. The annuity is £600 for the chiefs and their tribes to have on an annual basis, and that's the annuity that would be increased through the augmentation clause. The $4 per person would be increased at the discretion of the Crown. That's the interpretation that the court accepted in their judgment.
But as I understand it, that $4 was the first increase that ever happened. And it was increased in like 1874 to the $4, right?
That's right. Initially, the annuity was paid in the form of goods, all kinds of things that they gave to the Ojibwe people to accommodate that £600 of provincial crown currency. Fishing supplies, hunting supplies, traps, blankets, clothing, all of these kinds of things were given to the Anishinaabe, to the chiefs and their tribes. And the chiefs and their tribes distributed that to the people. But it became expensive to do that for the Crown. So then they decided what they're going to do is they're going to divide up that £600 amongst the, at that time they said there was something like 1,495 Ojibwe people. They were going to divide that up and make an annual monetary payment to everybody. So the Crown got away cheaper at that time, and it stayed that way. It stayed that way despite the fact that the Ojibwe representatives, Shingwakons and Nibenegooching and others, pressed the Crown to increase that annuity. And when we say that annuity, we mean that £600 of provincial Crown currency. So they pressed them to increase that because they saw a lot of wealth was happening, being taken out of the land at the time. And they wanted the fair share of that, That's how the Crown came about with the $4 per person. And it stayed that way.
For a long time.
For a long time. For a very long time.
It's just, I'm laughing. It's kind of unbelievable. So the annual annuity payment you mentioned, we know that it was increased in 1874, if that's correct.
Yeah, I think the increase actually came about in 1875, but 1874 was the time that the Crown agreed to increase the annuity, which was set at about, I believe it was around $1.60 or $1.70 per person at the time that the Crown was distributing to each of the Indians if you showed up there to get your money. But if you were in the bush, 15 miles in the bush, and you never heard when the Crown was coming to distribute this money, you didn't get it.
Oh, my goodness.
In any case, in 1874, they raised it up to $4 per person, and it stayed there because the treaty said that what would be given to individuals is £1 per year. So in those days, £1 was equivalent to $4. And it stayed that way. And the Crown interpreted that to be the ceiling. Anishinaabe were not allowed to have any more than that, $4. That was their interpretation of the treaty.
So then over that period of time, how did the Anishinaabe attempt to fight this? How did they attempt to rectify this grievance?
A review of the history of the relationship will show that the Anishinaabe people, the leaders, pressed from time to time the Crown officials to increase the annuity. Shingwakons himself, after about a year into the treaty time, said to the Crown officials, "You're not following the treaty the way you said you would, because we see development all over the place. There's people coming into the land, they're farming, they're harvesting in the forest, they're taking the animals, they're digging into the ground to pull up the precious metals, and you're not increasing the annuity." And the Crown officials said, well, that's at the discretion of the monarch.
So in the 1800s, the Anishinaabe were attempting, and what about in the early 20th century? Despite the fact, I guess, that the Indian Act prevented us from hiring lawyers to, fight for our rights.
That's right, yeah, because we couldn't access the court system for justice. Anishinaabe were not allowed to access the court system. You couldn't hire a lawyer to take your case into the court. So it didn't happen. It didn't happen. So the Anishinaabe leadership were constantly pressuring the government officials to increase the annuity. And as a matter of fact, one of the biggest things that occurred was in the early 80s when the Canadian government decided to patriate their constitution. The Native people in Canada got organized and went after the Crown for their protections. And a number of the chiefs from this area, from the Robinson-Huron Treaty area, Anishinaabe, went over to England to meet with the monarch, with the Queen. And they didn't get to see the Queen because she was out of the country at the time they got there. And they met with some officials over there. And they made their case there, and I think the Crown officials said, "Thank you very much, that's very interesting. Thank you very much for coming to give us this history, and it was nice to see you." And that was it, there was nothing, there was no resolution to the issue when they went over there to see the Queen. And so the Anishinaabe then decided that the only way they're going to do this is to take up a court action. So that was a process, and I became involved starting in 1992 with the process where the chiefs were talking about taking this case to court.
So I guess the chiefs decided as a collective to come together to bring this annuities case forward.
That's right, yeah. And the First Nations that belonged with the Union of Ontario Indians at the time in this area were called the Lake Huron Chiefs. And they discussed it each time they met. And, the Union of Ontario Indians, those groups met 4 times a year, generally. And each time they discussed how they were going to do this, how they were going to take this case forward into court. There was a little bit of a backlash as well, because the Crown said, you can't use the money that we give you, Union of Ontario Indians, to take a case up against us. So we had to find our own money to fight the case. So what the chiefs did then is they struck a working group. So several of the chiefs got together and they said, okay, we're going to try to find out how we're going to take this case into court, whether or not we can win it. So there was a working group that was established with a number of chiefs, and we put out a request for proposals to selected law firms to ask if they were interested in taking our case to the court. And we hired the one firm, Naugabo Corbier. It was a successful group to take the case into court. The next thing we needed to do was to try to find some money to fight the case. We looked at all kinds of different ideas. We proposed to 5 of the biggest banks in Canada through our legal team and asked if they were interested in funding the case, because our lawyers were saying it's very, very likely that we could win this case. And there was only one bank that came forward and said, yes, we can do this.
So finally, the case did go to trial. And I understand there were 3 stages of this trial. Can you talk about each stage?
Sure, yeah. The court decided that they should have a case management process to help to guide the case through the court system. In that case management process, all of the lawyers, both Robinson-Huron lawyers and Robinson Superior lawyers, were involved in that, in discussions with the Crown as to how they would approach taking the case through the court system. And they agreed that because of the magnitude of the information, evidence that was involved in the case, they decided to split up the case into 3 stages. The first stage would be to decide whether or not the law would provide the Anishinaabe with the authority and the right to take the treaty augmentation clause through the court system. The second part would be dealing with the arguments of the Crown that would prevent that. And some of the ones that I remember is statute of limitations. In other words, the case is too old, you can't bring it to the courts now. The other one is Crown immunity. You cannot take a case against the Crown about the land because the Crown considered that they owned all the land, so they had a right to do whatever they wanted. So those were the kinds of things that were in stage 2 of the trial. In stage 3, it was to determine how much was owed if we were successful in stages 1 and 2. Stage 3 would determine how much was owed to the First Nations for the failure to increase the annuity in the past, plus our ability to increase the annuity into the future. As well, one of the other items that was in the stage 3 portion of the trial was to determine who was liable to pay. Was it Canada, the Canadian federal government, or was it the province of Ontario? So that would have been determined at the stage 3 level of the trial. So that's how those 3 stages came about. We always felt that it was important for the elders to guide us. We always maintained that we wanted the elders to follow the case, to work with us, to give us direction in moving the case forward, because they have the history, they have the knowledge, they know the customs, and they made sure that one of the things that they said was that do not leave any Anishinaabe behind. That's very, very important.
So then what ended up happening in each stage?
What happened is stage 1, we won the stage 1. The court agreed that we had a right to take this into the court, so it could be decided by the court. And stage 2 was dealt with with Crown arguments against the case, where they said you cannot bring a case against the Crown. The limitations said that it's too old. You can't bring that forward. And so we won those 2 stages. Stage 3 was then scheduled to start. However, because we wanted to establish or reestablish a good working relationship between the Anishinaabe and the Crown in our territory, we preferred to negotiate a settlement rather than have a court order. Because in a court order, there's a winner and a loser. And you can't have a treaty relationship in that kind of a situation. So it was important for us to sit down and negotiate a settlement with the Crown. And the Crown agreed. The Crown agreed with that because of the statements of the court in the process. The court said it was very important for the Crown officials to sit down with the Anishinaabe to settle the matter. So we did that. We settled for past compensation. So this amount that was negotiated after stage 2 of the trial was just an amount that would satisfy the Anishinaabe for a payment for past compensation. It didn't have anything to do with any territory or anything like that. It was just an amount that the Crown agreed to settle the past compensation monetarily. So that's how $10 billion came about. The Crown and the Anishinaabe agreed to a settlement of $10 billion that would be dispersed to the chiefs and their tribes.
So that has come to pass?
That has come to pass. That has been completed now.
So that is a significant accomplishment.
Absolutely, yes. And I think it made the Anishinaabe people in the Robinson-Huron Treaty Territory much happier in living in their territory now, They had some justice, and it made people happy.
Mm-hmm, mm-hmm. So what are the next stages going forward? What's going to happen in the future for determining what the annuity should be? And then how will they go forward in calculating and determining this future annuity?
A big thing that happened is that Ontario appealed their case to the Court of Appeal. Ontario lost their case at the Court of Appeal. The Court of Appeal generally said that the Anishinaabe were entitled to have their annuity increased, and that the Crown officials, be it federal or provincial, were responsible for the increases that should have happened and should happen into the future because of the treaty. So we won that at the Court of Appeal stage. Ontario then appealed to the Supreme Court of Canada. At the Supreme Court of Canada, the Supreme Court said that the Crown had really treated the Anishinaabe really badly over 150 years, and really chastised the Crown for that treatment of the Anishinaabe people. And the court ruled that the Crown officials, federal and provincial, should sit down with the Anishinaabe and negotiate settlement of the case on a go-forward basis. So that's what we're waiting for right now. One of the other things that happened at the Supreme Court is the Supreme Court gave a 6-month window for Robinson Superior Treaty, and this is the only time I'm going to talk about Robinson Superior Treaty because it's in the Supreme Court of Canada ruling, that Robinson Superior Treaty ought to have a negotiated settlement for back pay in the same manner, similar manner to what Robinson Huron achieved. So they were given a 6-month window, and that 6-month window, I believe, ends somewhere around the middle of January, that Robinson Superior and the Crown should finalize a settlement of their, let me call it retroactive pay. And if that didn't happen, if they didn't come to an agreement in that 6 months time limit, the Crown was obligated to make an offer to the Robinson Superior Group to settle the back pay. And if the Robinson Superior Group accepted that, then the agreement would be finalized. If they didn't accept it, they had a right to take it to the courts to have the matter reviewed. I believe that this is what would happen after the settlement of Robinson Superior's back pay settlement. Once that was settled, it would be both groups, Robinson Huron and Robinson Superior, to sit down and negotiate with the Crown as to how the augmentation clause would be implemented on a go-forward basis.
So is that what's going to happen?
That's
then?
what will, yeah, that's what will happen. And it relates right back to 1850, because the Robinson Huron group and the Robinson Superior group were together in that negotiations in 1850. So today we should still stay together. You know, it's my opinion that we should stay together, and I think it very likely will.
So we know that now the chiefs and trustees of the Robinson Huron Treaty Litigation Fund, they've approached Ontario and Canada to abide by these directives of the Supreme Court and begin work on establishing the council fire. So I like the idea of that wording of council fire has been brought back into the terminology.
That's right. That was an important recognition by the Supreme Court of Canada that the council fire process was very important to treaty relations at least in our case. The council fire is the most important thing in dealing with treaty matters. And so the court ordered that the Crown and the Anishinaabe would recreate the council fire process to attempt to settle off the remaining matter of the treaty. And so we're in the process now of reestablishing the council fire. In the Anishinaabe tradition, it's very important to have the fire at the center of discussions. Wherever we are, we have always had a fire going because the council fire was central to our remaining together in a relationship, in a treaty relationship. So that's why the Crown, the Supreme Court of Canada, recognized the importance of that and the importance of Anishinaabeg traditions, like the pipe ceremonies and the sweat lodge ceremonies. These things are important as well as we go forward, and we will use those because that's Anishinaabe law. If the pipe is smoked, that's the law. So these things were recognized by the Supreme Court of Canada, and it's a very powerful ruling by the court to reestablish the treaty relationship between the Anishinaabe and the Crown.
Do you have a sense then, is it like reestablishing a new relationship, a stronger relationship, a more respectful relationship?
Absolutely. And I think that it's reestablishing what was there initially, that treaty relationship, that we respected each other, we promised each other that we would look after each other, and that's the basis of the treaty.
So do you find, in a treaty education sense, do you find everyday Canadians are aware of these important bases of our relationships?
Because those things were never written into the history of Canada, because they were never taught in schools, the vast majority of non-Indigenous Canadians are unaware of the treaty relationship that we have. They are of the opinion that the Crown, the British people, took over this land, which the church gave them the right to do. And so today they are of the opinion that the Crown owns all the territory, including the reserves, and the Anishinaabe are allowed to exist in there. That's not what the treaty is about. The treaty is about a respect between two nations of people. We have to keep promoting the treaty relationship. I think that's the most important thing in Canada. In the USA, they had Indian wars. Canada was settled by treaties all the way across this land. In those treaties, it was the underlying intent of those treaties was to live together in the land, to benefit from the wealth of the land, and so that we would both have good life, B'Madzuin.
Well, Mike Restoule, Chi-miigwech, it's been an honor to speak with you today. And Chi-miigwech for, the persistence, your leadership, your commitment really to this case.
It has been my pleasure to sit with you as well, Lisa, and it's been my honor to help along with the chiefs and the councils of the 21 First Nations to achieve what we have for the Anishinaabe people of the Robinson-Huron Treaty area. Miigwech to you.
Miigwech. Chi-miigwech to Mike Restoule for taking part in the podcast. In recognition of Treaties Awareness Week, many schools, libraries, and other organizations across Ontario will welcome guest speakers and host workshops related to the treaties in their respective areas. By learning more about our collective treaty rights and obligations, we can create greater understanding and nurture relationships between Indigenous and non-Indigenous peoples. To access free online treaty education resources, please visit the Anishinaabe Nation's Education Resources webpage. Find the link to this and more in the podcast description. This episode includes the tracks Brothers by Wolf Saga and Chippewa Travelers, Soft Spoken by Jacob Hoskins, Time to Move by Mimi Obonsuin, and Just Us by Wolf Saga and David R. Miracle, licensed by Nagamo Publishing. Chi-miigwech for listening to this episode of B'Madzuin Onindwa. Until next time, Bama Pi.